If you die without a will, you still go through probate. In fact, it's worse, a lot worse, than dying with a will. Because if you die without a will, you go through a special kind of probate, and it's called different things in different states. I practice in Texas, and we call it an heirship proceeding, or a determination of heirship. And what it means is that the judge doesn't know who's entitled to this property the deceased had when the deceased passed away. So the judge needs to figure out and needs to have testimony as to who the blood kin of the deceased are, because typically in some order based upon, again, your estate, certain family members are entitled to priority when it comes to property. Others, if they're more remote relatives, may not end up with any property. So dying without a will, frankly, is the, I'll use the term, stupidest thing you can do. Because if you don't have a will, or the alternative would be you don't have a living trust, then you've left no instructions. Let me assure you that every state has instructions for you, and your will, your trust, is written by the legislature of your state. Now, you may be a good Republican or a good Democrat, and you may love your legislature, but most people don't love their legislatures. The legislature doesn't know who you'd want to get the money. The legislature certainly doesn't know how much or how. Do you want to just give it to them? Do you want to give it to them in a little trust so that it's not lost in about 15 minutes? Dying without a will almost always includes having an extra lawyer or two, or three, or four. Because again, the court needs to figure out who the heirs are. Oftentimes it's going to be an extra lawyer hired by the family to go out and ascertain who the deceased children were, who the deceased spouses were, who the deceased cousins and other relatives are.